Good morning. I am Ruta Vaičiūnienė, and it's a pleasure to welcome you all here in the Child Hub platform and in this workshop that is part of our project, Procedural Safeguards of Accused or Suspected Children, Improving the Implementation of the Right to Individual Assessment. The project, which we, Law Institute of Lithuania, Center for Social Sciences, together with the partners from University of Zagreb in Croatia, Aristotle University of Thessaloniki in Greece, and Hope for Children Policy Center in Cyprus, are implementing. Actually, we are nearing the end of our project, and this whole workshop is one of the final activities. Also, at the moment, we are about to complete the most valuable outcome of our project, a handbook. And in this handbook, we provide a wide range of discussion, beginning with the most recent legislation on procedural safeguards and individual assessment of suspected and accused children, and concluding with an analysis of how 4 partner countries approach individual assessment and implement it. And yesterday I read forward to our book, which was written by Avril Calder, we have here today. And she's immediate past president of International Association of Youth and Family Judges and Magistrates. And she wrote that an individual assessment offers the best way of involving the young persons in their own future. So to begin the workshop, I would like to invite you today to consider and discuss the various approaches that could be taken to achieve this goal, to involve youth in their own future. Therefore, today we will hear good practice examples primarily from the Netherlands, but also from Italy, and we'll have good opportunity to discuss them with speakers. So take advantage of our speakers and ask questions. Only have in mind that the questions can be asked in a written form, as Thomas already mentioned. And if you find our workshop useful and valuable, please join us at our final project conference in June. And now I am giving the floor to our first speaker, which is Stephanie Rap. She is assistant professor at the Department of Child Law at Leiden University. Her academic interest lies in the field of the effective participation of children in legal procedures and decision-making. She studies child participation in diverse settings, such as in juvenile justice, child care and protection, asylum procedures, and in schools. In her research, she employs an interdisciplinary approach, combining international children's right and children's law with knowledge and insight from criminology, pedagogical science, and psychology. Stephanie, it's an honor to have you here. And please, the floor is yours.
Thank you, Ruta, for this very nice introduction and also for the invitation to speak today. I will share my presentation first with you, so you can see it. Okay. As I said, I'm very happy to be part of this webinar today. I have been involved in 2 other European-funded projects on individual assessments last year and this year. So I'm happy to be able to tell you a little bit from those projects as well, and to share insights from how individual assessment is legally framed. But also how it is applied in several countries. And about those different countries, I will discuss that in the second part of my presentation after the break. But first, today, in this first part, I would like to share some insights from international children's rights and child justice, as the UN Committee on the Rights of the Child calls it nowadays. Child-friendly justice, and how individual assessment as a notion is embedded in these legal frameworks, and how it is also how it is applied in EU law. But first of all, as Ruta already introduced, I'm a scholar. I'm working on several topics related to juvenile justice. I would also like to know a little bit more about the background of the participants of this webinar. So we have a poll to see what kind of background you have. So I'd like to ask if it is possible to share this poll. Yeah, thank you. And to take a minute to fill in one of the options that are applicable to you. So we have a little bit of an idea of the background of you all. So I think most of the participants have filled in the poll, and I see that so about half of them are doing actually individual assessments in practice with children and young people, and the other half, almost half are other people doing academic research, for example, and 2 people in the audience use individual assessments or the findings of it. So I'm very much looking forward, and also hearing from your side, from practice side, any questions you have or things you would like to add to what I will present today. And I'm sure that there will be enough time for Q&A about that. So it's good to know a little bit more about the background of everyone here. I think I can just remove it now from my screen, and I will start with the content of my presentation. So first of all, of course, I would like to say a little bit about the general overall international children's rights framework in relation to child justice, because we're talking today about young people who are suspects or accused in criminal proceedings. And first of all, when you look at the UN Convention on the Rights of the Child, Article 40 and Article 37 are of relevance here. Article 40 deals with the administration of juvenile justice, and also stating, for example, procedural safeguards for children who are in contact or in conflict with the law. And Article 37 deals with deprivation of liberty of children in the justice system, but also outside of that system. So in other types of systems where children can be deprived of their liberty in protection, for example, or in asylum. In 2019, the UN Committee on the Rights of the Child has issued General Comment number 24, which are guidelines or recommendations that the committee gives to states. And this one is specifically on child justice. And it is specifically an update of an earlier General Comment number 10, who also dealt with child justice. And in this General Comment, the committee states that individual assessments of children should have a multidisciplinary approach, and should be encouraged. So it should be something that states should be encouraged to take into account in their juvenile justice systems. And also that people who apply these individual assessments should have a appropriate multidisciplinary education or background in order to conduct these individual assessments. And then in this multidisciplinary aspect, I think is very important, and we will also see that in other legal standards, that this is something that's really stressed. Other important guidelines in relation to juvenile justice are those issued by the UN, for example, the Beijing rules, which were there already before the CRC was adopted, and also deal with the administration of juvenile justice. and also have some interesting rules or recommendations about, for example, the involvement of social work in juvenile justice, and that should also be an important component of dealing with children in contact with the law. The Havana rules are about deprivation of liberty again, and the Riyadh guidelines on the prevention of juvenile delinquency. So they also have a strong emphasis on the importance of social work in preventing delinquency from taking place. In Europe, I think the guidelines on child-friendly justice have had an important influence on how we look at child justice, and also specifically the involvement of children and parents in child justice systems. And I will, in the next slides, I will touch upon these guidelines in more depth. But they have a strong emphasis also on, for example, the participation of children in the procedures that take place. Important to this topic, of course, is the EU directive on procedural safeguards for children who are suspect or accused in criminal proceedings. So it is interesting to see that there's a complete EU directive on children in the justice system. And it has been adopted in 2016, and in 2019 the EU states had to implement it in their national legislation. So it gives a legal obligation to states to implement individual assessment procedures for children, but also other rights, like the right to information, which is quite a large provision in this directive. Also, the children have the right to legal assistance, that they have the right that their cases are dealt with timely, but also the right to effective participation in criminal hearings, trials specifically. And also it is stated that professionals should receive specific training on how to implement these procedural safeguards. Then when looking at the specific rights of child suspects, I think when looking at the CRC and its provisions there, you can say that on the one hand, there are rights enshrined in the CRC in relation to juvenile justice that make it a fair process, that ensure that young people who are accused or suspected of having committed a crime and also convicted in the end, that they receive a fair trial. So you can find a specific fair trial safeguards in Article 40, such as that you are innocent until the otherwise is proven, that you receive a lawyer, that there should be an independent judge who is looking at your case, that you have the right to be notified of the charges against you. But there are also specific, child-specific, child-oriented provisions to be found there. First of all, I think in Article 40, you can also see that there is a pedagogical approach towards children in contact with the law. That, for example, re-socialization is an important goal of implementing in the child justice system, but also that the best interest of the child should be a primary consideration. The CRC committee, first of all, in Article 40, it is also stated that there should be a minimum age of criminal responsibility, an age from which you are can be found guilty of a crime and also held accountable for that. And the CRC committee has stated that the age of 14 is an acceptable minimum age for criminal culpability. Internationally, I think 14 is quite a high age, maybe not so much in the European context or depending on where you live in Europe, but internationally that's quite high. And they have also increased that age specifically because in their earlier general comment, they said that 12 would be an appropriate minimum age. And now they've gone up also because they have been informed by research on brain development, for example, and adolescent development in cognitive abilities, emotional development, and stating that from the age of 14, you are better able to understand the consequences of your acts and be able to understand that what you have done is something that is against the law and should receive a consequence as well. Of course, when you look at this special child-oriented approach, parents are also of importance to engage. So parents have a specific role in juvenile justice proceedings, but it is also acknowledged that because children develop, their capacities evolve and develop, the role of parents becomes smaller or different to in the development of children and when young people are growing older. And for example, it is also stated that if children receive information, this information should be given directly to them in these kind of proceedings and not through their parents or a lawyer, for example. But on the other hand, parents should also be informed about the charges, for example, and about what the consequences are of being accused of a crime. This idea of child-friendly proceedings has also evolved, I think. Of course, in the CRC already finds in Article 12 the right to be heard for children in all legal proceedings, including also in criminal proceedings. And as I said, for example, in the guidelines on child-friendly justice, this has been more developed and made more concrete. Also, what does this mean in specific proceedings? This child-specific approach is also seen in the idea that diversion should be a first choice when children come in contact with the law, so that it should be prevented that children are criminalized and also going through full-fledged criminal proceedings, especially when they are first offenders, for example. So it should be tried to see if extrajudicial dispositions or procedures are possible to give a reaction to their criminal offense, but not so much stigmatizing them with being an offender and being convicted of a crime. Of course, in Article 37, it's also stated that detention should be used as a last resort, so minimum use of detention and also for the shortest appropriate period of time. And that is also, of course, up to discussion how long the detention should be, but hopefully really a short period. And as I said already, focus on reintegration and resocialization of children to prevent crime from happening again and to help them in developing towards normal pathways and trying to prevent them from coming into contact with the law again. And as I said, the right to individual assessment as such, we can find in the new EU directive on procedural safeguards of children. So to summarize, I think the international community also acknowledges that child justice is a human rights issue, that we should guarantee a fair trial for children, and that they have the same procedural rights and safeguards as adults, although some might be a little different. For example, that we also acknowledge the privacy of children in these kind of proceedings, in, for example, having hearings behind closed doors. But also, they have the right to a fair trial, in the sense that they should be able to participate in these trials, and that they also have the right to a lawyer, for example, that helps them throughout the procedures. But on the other hand, we also acknowledge that this child-specific approach also means that we acknowledge that children are still in development, and that it is acknowledged that we have a positive view on that, and we think that they can still be restored and reintegrate into society. And that we should also develop specific interventions in order to accomplish that goal. And I think as a European, in the European context, I think you can see that very well in the different child justice systems that are developed in different countries. There are, of course, a lot of differences between states in how they apply it, but some overall characteristics or things that are sort of the same are so that priority is given to educational sentences. Not only punitive or deterrent sentences, but also that children and young people really learn something from it, and that the most appropriate sanction is tried to be found to be given to a child in a specific case. On the other hand, the principle of proportionality is also of importance here, so that the sentence is also proportionate to the offense that has been committed, so that it is not at least in criminal or juvenile justice proceedings, not the idea to give very strict and very long sentences to children who only committed minor offenses, and that is also one of these fair trial safeguards. And I think also in the European context, you see that there's a lot of attention for the idea of restorative justice, and that restorative justice can also be one way of achieving reintegration into society again, and also maybe a way of using it as a form of diversion in the early stages of a procedure. And restorative justice is, of course, very much grounded in the idea that the relation between victim and offender or suspect is restored by putting in place specific interventions, such as mediation, for example, or having the suspect send a letter to the victim. Some time ago, Professor Dunkel already distinguished an ideal order of level of sanctions, also based on these children's rights and human rights principles, that you should use diversion and also proportionate sentencing. And he stated that the start should be to start with warnings, reprimands, and not with very invasive sentences at the beginning. Also, of course, depending on the offense, of course. Then appropriate sentencing would be more like fines or community service. And I think fines are also something that is used very differently in different states. Whether it is really effective to give a child a fine. For example, in the Netherlands, we don't use it that much because we think our parents will pay for that, and it's not really a consequence for the child to receive a fine. So we use community service a lot. Then a little bit more, invasive or intrusive sentencing would be to really apply training courses and other educational sentences to young people. Then probation, and then moving more towards the privation of liberty in the sense that electronic monitoring is applied maybe, or even placement in an institution. But that should be the last resort measure according to the international framework. Then moving on to the guidelines on child-friendly justice, because I think these guidelines give also some specific guidance on how individual assessment should be applied. And first of all, to start with what, how child-friendly justice is defined by the drafters of these guidelines. It has been issued in 2010. And they stated that child-friendly justice refers to justice systems which guarantee the respect and the effective implementation of all children's rights at the highest attainable level. So they have a very broad definition. And also in the document, you see that many children's rights are enshrined in there. But they also state that consideration should be given to the child's level of maturity and understanding. So taking into account the age and level of maturity. And also specifically that children have the right to due process, to participate and also to understand the proceedings. So here you see also this combination of fair trial proceedings and guarantees on the one hand, and also specific acknowledgement of children having specific rights and also specific needs in that regard. And on the slide, you see that these are the fundamental principles of child-friendly justice as formulated in the guidelines. Participation of children and acknowledging them as full bearers of rights, that their best interests are primary consideration. And you can understand also that, for example, when we talk about young people who are suspected or accused of a crime, that how to define this best interests can be quite difficult. And of course, there are more interests also at play in criminal proceedings, such as from victims or victims' family or society at large, for example. So it's not always an easy exercise to balance all those rights. Of course, the dignity of the child should be respected. And here you already see also that attention should be given to the personal situation of the child, his or her well-being and specific needs, and also respect for his or her physical and psychological integrity. And I think that is something that also very much relates to the idea of individual assessment. That you need to do some type of individual assessment to know more about the personal situation of the child. His or her well-being, also specific needs, also in the proceedings. Of course, protection from discrimination, and also specific protection for vulnerable children. I think in all of Europe, children from specific minority backgrounds have a more vulnerable position in legal proceedings, but also which is very, I think, also a topical issue in juvenile justice is also children with specific disabilities, for example, or mental disabilities, difficulties with comprehending information or speaking or interacting with adults, for example, which should be taken into account. And the rule of law principle, which applies again to this idea of, okay, children are different, but they also have, the same rights as adults do, and the same, they should be accorded the same protections at least. Then when looking at it more in depth in how this idea of assessment is implemented or defined by the guidelines, it is stated that it should be an assessment of the legal, psychological, social, emotional, physical, and cognitive situation of the child, which is also quite a large exercise. That there should also be developed a common assessment framework for professionals of different expertise, also who work with children. So they specifically mention lawyers, psychologists, physicians, police, but also immigration officials and social workers. So they should have a common framework in how they understand the needs and the rights of children and how that is assessed. Then also that these assessments should be done accurately and also using multidisciplinary methods. And they also in these guidelines acknowledge that it should be balanced with the interests of other involved parties, such as parents or victims. And it should be done professionally and on a case-by-case basis. And that is case-by-case is also the individual part of it, I think. But they also acknowledge that this is a very complex exercise, and in practice, I think everyone can relate to that. And in the end, this multidisciplinary approach they find very important, and they also state that it's important to have understanding then of children's psychology, their development, their needs, but also their behavior and how their behavior is influenced. And I think June in the afternoon will give some more information on that, on how children develop and what kind of factors influence that development. but also that professionals, legal professionals also needs to be given that knowledge and need to be trained on that. Oh, yeah. Based on these guidelines on child-friendly justice, I would like to point out to you this checklist for professionals, which has been developed by the EU Fundamental Rights Agency. And I think it's very interesting to have a look at it when you have the opportunity, because it's sort of a checklist to state yeah, what actions you as a person or as an organization can take to make the proceedings more child-friendly. So it gives some guidance on how to do that really in practice. I will not go through it in depth now because I don't think we have the time for that, but yeah, I hope you'll have the opportunity to have a look at it, because they have also translated it in several maybe all European languages, I'm not sure, but you can find it in different languages. Then to go on to the specific obligations that come from the EU directive. In another project, I also looked at child victims and individual assessment for child victims. So I also left it on this slide because maybe for some people that might be of interest as well. But in this presentation, I will focus, of course, on child suspects and accused. And Article 7 of the directive is of main importance there, because that's stating that individual assessment needs to take place. And for child victims, it is scattered around different EU directives where we can find the obligation for individual assessment. But of course, the EU Victims Directive is of main importance. And you can see that these directives are from 2012 and 11 already. So that's already then also it was acknowledged that these children need to be receive an assessment when they are involved in certain criminal proceedings. Of course, the EU law sets out general obligations to states, and national law and practice should implement these general obligations. And it also may be possible to do that in different kind of procedures, and there are different possibilities to do so by states. But I will look at what in general the obligations are right now. So it is stated that it should be a multidisciplinary and also robust individual assessment at the earliest stage possible. And there's also some debate about what is then the earliest stage possible. And that it is given for children who are suspected or accused of a crime, and also that definition may differ among states, or when you are a suspect still, or when you move to the to the standard of being accused, officially accused in criminal proceedings. So it is an obligation to do these individual assessments and to make them available, and also to carry them out in a child-friendly way. And this child-friendly way, I think it's important to further define it also, to know what is then child-friendly. What do we understand by being child-friendly? And I think in the second presentation, I will touch upon that also a little bit more concretely. So the scope of individual assessments, what should be assessed and how should that be done? So it's important to assess the specific needs of children concerning their protection, education, training, and social integration. So this looks very broadly at what the needs are for a child at a specific situation, and also to it's not specifically saying something about the offense or the chance that the young person will engage in criminal behavior again, but it's really having a more positive outlook on, okay, how can we protect the child in his or her situation? From the idea that there is some protection needed to prevent maybe a further involvement of the system. And that education, training, and also a social reintegration are needed for that. the child's personality and maturity should be taken into account, but also the child's economic, social, family background, and also specific vulnerabilities. And with these specific vulnerabilities, I think it is important to also look at specific disabilities a child may have, or specific difficulties, for example, learning difficulties, and also understanding of the proceedings, and that throughout the proceedings. Because in many proceedings, of course, it is acknowledged that the children should be treated differently from adults because they have are not at an adult level of development yet, and they need more help, and yeah, also in understanding and participating in proceedings. But I think with this individual assessment, it can be made more tailored, a more tailored approach to very specific difficulties a child can have. Because of his or her background maybe, or level of education, or maybe also ethnic minority background and how it has grown up. Another specific element of individual assessment is that it can also be looked at what kind of precautionary measures can be taken in the proceedings. So then we're looking more at pre-trial measures, to what extent they can also already be implemented or are needed, for example, concerning the protection of the child. And also, of course, the measures that can be taken whenever the child is found guilty or not. It is also stated in the in this provision that the extent and detail of the assessment may vary according to the circumstances of the case, the kind of measures that can be taken, and also whether or not in the recent past an individual assessment has been already done. So this is also a little bit, it relates to the idea of proportionality. So do we need to go through a full-fledged individual assessment for every child every time it comes into contact with the law? Member states have said that that is not necessary, because of financial resource constraints that they have, but they would like to say, okay, based on the circumstances of the case, we will assess whether an individual assessment is needed. And for example, in the Netherlands, there are also a lot of diversionary measures taking place. For example, young people who come in contact with the police for the first time go to a diversionary program, which is like a community service for a maximum of 20 hours. And for that, the state has said, okay, a full individual assessment is not needed, only when there are sort of markers that indicate that more is happening in the life of the child than only a once in a lifetime offense that has been committed, also a very small offense. Then how should it be undertaken, this individual assessment? It should be carried out at the earliest appropriate stage of the proceedings, which is also, yeah, the states are given discretion to when that takes place. Then what is the earliest appropriate stage? Also, it is important that the child is closely involved in the assessment. So also the views, the wishes and the needs of the child should be taken into account in this assessment. And I think in the second part, I will say a little bit more about that, this idea of participation. Then it should be carried out by qualified personnel following a multidisciplinary approach. So different, maybe different professionals should be involved as well to conduct this individual assessment. And also parents or other people who are having a parental responsibility or an appropriate adult should be involved also in the individual assessments. So they should have also a place in there, and maybe also provide information on how life is going for this young person. Then I would like to go in look into detail a little bit more into what this idea of the earliest appropriate stage is then for an individual assessment. The EU directive states that it should be before indictment for a child suspect or accused. But there's an exception possible. It should be possible also to present an indictment in the absence of an individual assessment, in case that is in the child's best interest. It is indicated there that, for example, when the child is in pretrial detention, it should not have to wait for a very long time for an individual assessment to take place before this pretrial detention can be the child can be released from there, because otherwise, yeah, the young person will stay into detention for a much longer period of time, which is not always necessary. It can be released under specific conditions, for example, before a full individual assessment has taken place. But in the directive, it is stated that the individual assessment should be available before the court hearing takes place. So that is quite of a hard requirement. But also circumstances of the case and the interest of the child always play a role in there as well. It is also stated that if elements change or circumstances in the life of the child change, that then the individual assessment should be updated throughout the proceedings. And I think this is quite an important aspect, because when the individual assessment takes place very early in the proceedings, and proceedings take a very long time, then a lot of developments can take place. Maybe interventions are already applied pre-trial, like probation, for example, or other training courses. And then, yeah, the individual assessment may need to be updated because the young person has developed and also has indicated or shown a very positive behavior in the meantime. But sometimes I think it is also, I've heard, for example, in the Netherlands from professionals, that this is also a reason to delay individual assessments sometimes, or reports to the court, that because they do not want to make updates all the time, but have an accurate picture for the judge at the time of when the judge has to look at the case. So then may some smaller individual assessments take place, or less extensive ones at the beginning of the proceedings to see, okay, what route do we take, where do we go with this young person, and then a full individual assessments only take place, yeah, when they know that the case hearing will take place within 6 months' time or so. So yeah, states give different meaning to this idea also. And again, I put in here that victims should also receive a timely assessment. But for child victims, many times they are involved, of course, in general criminal proceedings when they are victim of a crime committed by an adult, for example. So not so much, there's not so much involvement in juvenile justice proceedings, I believe, as for in criminal proceedings. Then who will use individual assessments? Of course, they are, the main goal is that the competent authorities will use the results of an individual assessment, and the competent authorities are those that take the decisions in a case at different levels, of course. So it can also be prosecutors who can apply certain diversionary measures, acquit a case, for example, or under conditions apply a certain, for example, probation, so that later on the young person will not be sent to court anymore. But also, of course, in courts where judges have to treat these cases. Then also different authorities may be involved in implement of, in also carrying out individual assessments and also contributing to individual assessments. And also a number of agencies can work together to make individual assessments. But it really also depends on how this is organized per country. And again, from the Netherlands, I can give the example that there are a lot of case consulting meetings. I think in the Netherlands we are quite good at discussing things together before reaching a decision. So already at the police level there are members of child protection boards, but also for example, representatives of victims involved in seeing, okay, where do we go with this case, and what kind of diversion is possible for this young person, and also at the level of the prosecutor, and it is discussed again where the case will go. But it means that agencies have to work together and also understand what they can contribute to this individual assessment. And also, I think individual assessments can be very important for people who are the representatives of the child and their parents, such as lawyers, for example, but also other family members or a guardian that is involved. Because they receive valuable information, also in-depth information on the personality of the young person, and also then they can advocate, for example, before a judge or a prosecutor for certain dispositions, or also maybe certain adaptations during the proceedings. Because really depending on the goal, of course, of an individual assessment, does it only lead to knowing what would be the best appropriate sentence, but do we also maybe want to make certain adaptations in the proceedings based on the needs and the vulnerabilities of a young person? And lawyers can use information from there to advocate for their case. So what I would like to ask, this is a list of with questions basically where you can think of to make sort of an assessment of your own situation and your own individual assessment in your country. But I would like to ask Thomas to set ready the second poll. Because I'm in the second poll that I have developed, I have the I would like to learn more about your views on individual assessment. So I would like to ask you to fill this in and to think of what does individual assessment mean to me. What is the most important element of what I would like to achieve with individual assessment? So I'm looking forward to your votes. And also maybe to discuss this later in the Q&A to see why you've given this choice, for example. So it was possible, I think, to give more than one answer, and I see some of the popular answers is to get to know a young person, but also to make a risk assessment. I think that's very interesting because a lot of individual assessments also are originally based on that, to assess the risk of the young person to reoffend, and to on the basis of that also decide what would be the best appropriate disposition, but also to assess the vulnerabilities of the young person, which is also an important element, I believe. To determine the best appropriate sentence receives a little less votes, 46%. But assess the needs for specific adaptations a little bit more, 51%, and also to assess the situation of the young person at home, in school, and with friends receives a lot of votes from you, and that I think also overlaps a little bit with the idea of getting to know the young person, or gives us a little bit more concrete guidance. I think 2 people have voted also to other, so I would be curious to know what the other elements are of individual assessments that you did not find in here. So if you so feel free to also indicate that in the chat what other options you think are appropriate here. Interesting to see the results of this poll. but also that most of the elements are quite even distributed here. And yeah, I look forward also to hearing more about this from your side. I will remove it now from my screen. So yeah, this relates also to, yeah, I think an important question that should be asked also by states in general, but also by organizations who implement individual assessments. So why is it undertaken? What goal does it have? Do we only have to know, okay, what sentence should we apply in this specific situation? Or do we want to know more about this young person? And or do we have more of a welfare approach and look more into, yeah, how can the young person be protected from committing more crimes or being more involved in with the police, for example. And that also relates to the scope of the assessment and how extensive it should be. And it also will probably depend on the type of procedure, whether this is more diversion or really a very serious case in which a very long sentence can be applied, where a much more in-depth personality investigation has to be conducted. So I think there's sort of an yeah, different elements I think that are interesting to discuss further. Yeah, to make services more individualized, maybe how interest of the child has a role in this whole idea of individual assessment, and also to what extent can yeah, the outcomes of individual assessments also be applied during the proceedings, before a proceeding starts, when a young person has been arrested, for example, but also during and after the procedure. So this was the first part of my presentation, and I look forward to any questions or comments or experiences that you would like to share. Contributing to the outcomes of a child justice process. So it's not oriented at impact, and it should be more, so that the results are really used also in the proceedings and in the outcome of the proceedings. And it is taking place ad hoc, and not really having the aim of making progress, progress-oriented outcome of the individual assessments. So these were all the challenges and the limitations that they identified in this process or in this project, and they also identified what could be done about this, also taking in mind the International Children's Rights Framework, and also specifically the EU regulations that apply here, specifically the EU directive. So to clarify this a little bit more, these 10 points, I'll go through them. Starting with the idea that individual assessments should be a holistic and comprehensive process. And in this project, they also focused on child victims. So the idea was that for child suspects and for child victims, similar processes for individual assessment should be in place. But also specifically for child suspects, it was also indicated that it is important to look beyond the juvenile justice system and also involve the child protection and welfare system, and to make more crossovers between those systems if they are not already linked to each other, so that it would be easier also to apply protection to young people, not specifically as part of a criminal proceeding, but more in a welfare system. The idea of holistic or holistic approach is also that the whole situation of the child is assessed, not only looking at risk assessment, for example, in reoffending, but also to looking at other life domains and how the child develops. That also adequate sources of information should be used about the child's circumstances, so that it's not only one-sided information from the police only, for example, but it's other sources, and specifically also the child and parents themselves, or parents, are included as source of information, but also maybe the school, for example, or other social workers that they are involved in already. That the processes are also similar for all children, and I will explain later a little bit more about that, because in different countries you see that individual assessments take place, but not always using the same framework or the same sort of list, for example, and that it depends on the social worker how it is executed and also put on paper. So the involvement of both criminal justice and child protection, this also means that there should be communication between both systems, and also maybe information that could be exchanged. And also, of course, there it's important to acknowledge the privacy of people, and that also parents and children should be given consent maybe to exchange information between different organizations. And the assessment should address all the needs of the child, and also to consider all kinds of appropriate measures throughout the proceedings, and having a clear focus and emphasis also on social measures, not so much punitive types of measures. Then the element of inclusiveness. The idea is that the needs of all children should be assessed, regardless of their age, nationality, personal circumstances, or characteristics. So this really relates very much to Article 2 of the CRC, the principle of non-discrimination. And the idea is that all children receive individual assessments. And as I explained before already, in the EU directive, there are some remarks made about depending on the circumstances of the case and the best interest of the child. And that gives states some leeway in applying individual assessments as well. If they think the circumstances of the case need, for example, a quick follow-up and for only a reprimand or warning or a diversion that has low impact on the child, then they can decide to not put in place individual assessment, or maybe less comprehensive type of individual assessments. But this project really emphasized that it should reach all children. And this is also mean that specific attention should be given to children of diverse backgrounds. That gender issues should be addressed, children from LGBT communities, medical needs that children may have, also children from different ethnic minorities, and also children with a Roma background, for example, which is in some countries more relevant compared to others. Special steps or measures should be in place to address the situation of these children and also their specific needs, also relating to maybe the diverse backgrounds that they have. And also you need, of course, specialized expertise where necessary. And also it is indicated that, for example, sometimes maybe interpreters are needed as well if children are migrant children who come in conflict with the law and do not have sufficient possession of the language of the country. To go to the next point, the idea is also that it should be a participatory process. So it's not only about the child, but also with and for the child, and also to inform children and young people, to give them support and assistance throughout the process. And I think individual assessment can also provide a platform or an opportunity also to give information to the young person about the proceedings, about what will happen, what type of advice also will be given to a judge or prosecutor on the disposition, and not only to receive information or to extract information from the child, but also to give information. This acknowledged that this should be also age appropriate, of course, and child-friendly information. And that also the privacy and consent of a young person is important here, that they know why they give information and where it's used for, and that they also give consent for the contacting other people in their environment, for example, a school teacher, for example, and how that information will be used in the individual assessment and what kind of consequences that will have. And examples that are given here are specific leaflets also for children and consent forms. But I think it's important also that social workers who conduct, for example, these type of individual assessments can also give information to children when they are talking to them, and also have some understanding of the legal proceedings. The fourth point is about that it should be a child-centered and also a child-sensitive process. This is also generally, you can state this for juvenile justice proceedings based, for example, on the guidelines on child-friendly justice, that proceedings, but also these individual assessments should take place in child-friendly places also that are suitable for children. And many times you see that, conversations and interviews with young people, children are held in more office-like buildings and settings. And maybe sometimes it's also good to have other types of more child-friendly environments available, and mostly you see that with younger children, that these adaptations are made, that there's a different type of interrogation room at the police, or for migrant children who are below the age of 12, but not so much for young people who are 12, 14 or older and involved in the justice system. Also, what I would highlight here is it's important that there's a person of support, maybe a parent or another person that the young person trusts, or a social worker, for example, who can support him or her throughout also the individual assessments. And another point, I think, which also comes from research, is that it is important that young people understand what the goal is also of this assessment. Why is it done? And what is the goal of the organization that does it, and how does it impact also in the end the course of the proceedings and the final outcome? Which decisions can be taken regarding diversion, for example, or a trial, and what kind of sentences or dispositions can be taken or given to the young person. Then the aspect of continuous and timely individual assessments. So we already spoke about that it should take place at the earliest possible moment, and that it should be updated also throughout the proceedings if needed. It is. The idea is that it should take place around the first contact of the child with law enforcement or a social professional. And that means also that, for example, police officers should be aware of this and also should be trained in doing a certain type of assessment, and also knowing what to ask, for example, and also how to report that and how that report will be shared with other parties. And as I said already, it should be a system that could be updated throughout the proceedings. And I think here it's also very important that it is known in the system or in the country who is responsible for doing so, and that also professionals take the responsibility in making certain updates, for example, and find it important to do so. And that also the room exists for that, to make these updates. That is not something that is seen as, okay, it's really difficult because it will change everything and will have a lot of consequences for certain decisions, but that is something that is really beneficial for the child as well, and the young person. Then the sixth point that they identified in this project is that it should be a multidisciplinary and a collaborative exercise, actually, that individual assessments should involve different professionals. And I think in the first part, I already emphasized this, that there is a lot of attention for the idea of multidisciplinarity. In practice, I think In a lot of countries, individual assessments are undertaken by social professionals who are already have knowledge about the development of young people and about their background and indicators for how they develop and doing so in a positive way as well. But it is also important then that this is also translated to legal professionals, and that legal professionals are also involved in this process, because they can indicate also what is possible in the legal context. What kind of measures are available, what could be applied in relation to the seriousness of the offense, for example, or whether the young person has come in contact with the law before or not. So that's, I think, also why it's important to involve people from different disciplines to come to a more comprehensive assessment and also an outcome of the individual assessment, so that you know, okay, because when a young person has committed a not very serious offense, maybe only had a fight with another peer of him, friend of him, which was not very bad, and there was not so much harm, but maybe there are a lot of underlying issues taking place in the life of the young person, a lot of problems. Maybe his parents are getting divorced, or it's not going well in school, and things are piling up. Then in the end, the offense will not show or leads to a very comprehensive sentence, for example, or a longer time of supervision or whatever, because that's not needed. But other indicators state that maybe the young person needs some help and some support in getting on the right track again and not displaying this behavior more often. And then that relates to involving maybe also social work, child protection, and not only dealing with it in the juvenile justice system, because that might not be proportionate as well, or maybe also stating to the parents and the young person that they could find help elsewhere or in voluntary setting. And it also may give some indications of that it can be a more holistic process in that regard. What's also on this slide is this idea of case management, and meetings, having meetings between different partners who are involved in juvenile justice and maybe also child protection even, to come to an idea of how we can help this young person in this juvenile justice process, and what route to choose among the different options that are there. Number 7, that's about the quality of individual assessments. So it is stated that it should be undertaken by qualified and trained personnel, and that they need specific qualifications or experience also, and that also the right range of professionals are included. I already indicated that, for example, police has an important role in here to play as well, because they are the first gatekeepers of the system. They see who is coming in and who they also encounter on the streets, for example, and seeing them doing things that are not allowed, but also, of course, social work. And in a lot of countries, social workers are very much involved also in juvenile justice proceedings. They work either for the courts, or it's a separate organization that can independently advise courts and prosecutors. And of course, the courts and lawyers are also persons who can also engage or contribute to this idea of individual assessment. Lawyers represent, of course, their clients, and they have mostly a legal look at the case to see whether the young person is guilty or not, and how to proceed in a case, and what kind of dispositions should be applied. But if they also look at more the social aspect of the young person, they can also maybe tailor their approach to that in the courts. So it's also indicated as for process that has a high quality, regular training is needed, and training standards should be identified. And maybe also that there should be specialized teams available about who deal only with cases of children and young people. This is, of course, all depending on how states have organized this, and also internationally. The CRC committee has stated that states are open to have specific specialized juvenile courts or juvenile justice systems, but it is not necessary to do so. And later on, I will give the example of Finland, for example. And in Finland, there is no juvenile justice system, but they have special rules and adaptations for young people and young adults also. And also, it really depends on the infrastructure of the country as well. And in some densely populated areas, it is possible to have a very specialized units in the police, for example, or in the courts for children. But when you are more in rural areas where not so many people are living, it might not be feasible to have specialized organizations. But it is necessary to have people who are specialized in these organizations. Or that should be, that should be a good standard to have. This brings me to the 8th point on properly resourced and sustainable services and systems for individual assessment. Therefore, it is very important that also funding is available to support these individual assessment processes, so that governments in other ways it's organized maybe differently by states, dedicates funding to make this possible. That organizations have the people available also, and then the resources to do so. For example, that caseloads are not too high, and that they can live up to the numbers also that of court cases, and that also individual assessments can take place in all types of cases, and that no decisions have to be taken based on their availability and the availability of financial resources, for example. And also it is important that some tools are available also to make these individual assessments. That relates also to that it should be comprehensive and the same for everyone, but also it could make the process more efficient, and also for people also to take it over and to learn also how to do these individual assessments. And I think that's important in making it more sustainable as well, and to improve maybe the system throughout the years, for example. Then the 10th point that they highlight, oh no, I skipped one, I'm sorry. Going back, impact oriented. So that relates again to the goal of individual assessment. Why do we do an individual assessment for juvenile suspects and accused? The point here that is made is that it should have concrete outputs, and that it should be geared also to fulfill the rights and the needs of children. It can contribute to a range of different goals and measures that can be taken in juvenile justice, like, for example, to make sure that the procedural safeguards for young people are implemented adequately, but also that the educational, social, protection and health needs of the child are taken into account, and specific measures can be taken in that regard. And that relates to creating also real impact with individual assessment, so that it is really the needs of the young person that are assessed, taken into account, and that a concrete measure is applied as a result of that. And that's also it requires the involvement of different agencies and different professionals who can also implement these measures. So maybe, the school could also be involved, when the young person is doing not so well in school or skipping school, and as a result of that is displaying delinquent behavior, then the outcome could be that the school could be involved more in curbing this behavior. And that requires also maybe sometimes that something is asked from a school to do, which it would normally maybe not be involved in. Then I think it's also important that, again, we look beyond the juvenile justice system as such and see that also maybe the welfare and the needs of the child are important and should be addressed as well. The final point that they identified is that it should be progress oriented, so also contributes to learning, and that means that the process of individual assessment should also be reviewed so that improvements can be made, and that means as well that also professionals should talk about how individual assessment takes place and how it can be improved, and also maybe leads to more concrete results. Therefore, always it's important to collect data also on specific indicators. So maybe data could be collected on the outcomes of individual assessment, and then the follow-up, what is done with these outcomes, how did young people develop, maybe not only about whether they offended again, but also on other indicators. And then based on that, maybe some changes can be made. And also, for example, if certain dispositions or sentences are advised, to what extent are they actually implemented in the end? And do judges or prosecutors see it as useful, or do they go their own way and think of their own sentences to apply? So that is, I think, important to receive also, or to make some progress in individual assessments. And promoting public awareness is on this slide, and also learning from international good practice. And I think this webinar is an example of that final point, that we would like to learn from each other as well, and see if we could improve our own system by that. And that's what I would like to touch a little bit upon right now, to explain a little bit on how individual assessment works in different other countries. I know that my colleague June will talk, I think, a little bit more in depth about the Netherlands in the afternoon as well. But on the next slide, I will say a little bit about my home country in this regard. As I indicated before, the EU states had between 2016 and 2019 to implement the provisions of the EU Directive on Procedural Safeguards for Children, and in per June 2019 had to be fully implemented. And in the countries that we've looked at before, I think specifically in Northwestern Europe, individual assessment was something that was already done by states. But not codified as such in law, and that specifically also happened in the Netherlands as a result of the directive, that in the law it was stated, okay, individual assessment is something that is needed in all juvenile justice cases. I know in Belgium, at least in the Flemish part, they are now going through a law reform on juvenile justice. But I don't think that on individual assessments so much will change. The case there is that there is a social service, a social work service that works specifically for the juvenile courts there. And traditionally in Belgium, there was a strong link between child welfare and child justice. And for example, the courts and the judges deal with both types of cases. And also, in the past, delinquent behavior was more seen as a problem that was an indicator of larger problems in the life of a young person, and that welfare and social reactions should follow. And they are moving a little bit more towards a traditional justice system with sentences, for example. But still, I think there's a lot of attention in Belgium for looking at the personality of the young person and his or her social circumstances, and also to see if, for example, provisional measures should be applied in the provisional stage of the proceedings, so that already at an early stage, support and help can be given in the form of probation, for example, or community service. And no time is leaking away and waiting for a final judgment in a trial, for example. However, we also found that there's no standard format for these social reports. So there's much variation also in the quality and in the detail of these reports per court, mainly because social services work specifically for one court. But overall, they are made or implemented by trained social workers who are experienced in doing this, and also providing the judge with real recommendations on how to implement certain measures. Children and parents are also included, of course. They are interviewed for these reports. In Belgium, there's a strong focus on restorative justice measures. So it is possible, even for the young person, together with his lawyer, to propose restorative justice projects to the court and stating, okay, I would like to do this restorative justice measure, like a mediation, for example, or writing a letter, or they can propose different projects to also restore the case. So they have a strong emphasis in doing so. Then to move on to the next one, I also looked into how Finland deals with individual assessment. And as I indicated before, in Finland, there's no separate juvenile justice system. So that's quite interesting. And you also see that, for example, in Sweden and Norway and Denmark, where there is an age of criminal responsibility, which is 15. And it means below the age of 15, when you commit an act that would be a crime if you were an adult, then you're dealt with in the welfare system, a social work system, and not in the justice system, and also not punished for your delinquent act. But from the age of 15, you can be suspected of a crime. But specifically for Finland, there's an act on investigating the circumstances of suspected young offenders. So it is mandatory that for 15 to 20-year-olds, a pre-sentence report is drafted, specifically when the sentence will be expected to be more than a fine. And there is a specific community sanctions agency who also implements probation, for example, for young people, and they also make these reports. And it is about preliminary measures again, but also about the dispositions that the court can give. And they also make a sentence plan, a preliminary sentence plan on how they will implement, for example, a probation measure. This is all carried out by qualified probation officers, and also the child or young person and his or her parents are involved. Again, it is interesting to see that they also do not have a standard format. They have a format which was borrowed from the Netherlands, actually. It's the old format that we use, that some of these agencies use, but not all of them. So they work with, of course, qualified probation officers, but the reports can differ among different courts in how they implement this. And then to the Netherlands. So in the Netherlands, we have been doing, I think, individual assessments for quite a long time. And the main organization that is responsible for that is the Child Protection Board. So the Child Protection Board investigates cases of child abuse also, and whether a child is in a circumstance of needing protection in the home, but also in the juvenile justice system. And they have developed a It's called a national instrument on juvenile justice. And later today in the afternoon, June will explain more about the contents of that instrument. But the idea is that it is, there are different parts of it, and the police already starts with filling in the first part of it. And then later on, the Child Protection Board starts with the large part of doing the whole investigation. But at the level of the police, they already look at what kind of factors can be identified that also really specifically look at the risk for reoffending. So that is an important aspect. And also, I also looked at England and Wales, for example, and there also there's a large emphasis on risk assessment in these kind of instruments. Although in this Dutch instrument, there's also quite some attention for school and family life and friends, for example, and the whole life of the young person. What was newly introduced here is that there is also a child letter attached to it, which is a summary of the report, which is given specifically to the young person and his or her parents, with in clear language, so that they know what's the in plain language and in the summarizing form what the outcome is of the individual assessment. And I think that's very good, because these reports can be quite long. They can be maybe 10 to 15 pages. And then, it's good to have a short summary that hopefully the young person will read and has, takes less time, of course, to read it. The judge or the prosecutor uses these reports in the final disposition and choosing that one. And in the Netherlands, you see that in a lot of cases, the judge follows also the recommendations made by the Child Protection Board in these reports. So if they state, okay, community service and probation is needed, then in many cases they will also apply that. And during the court hearing also, mostly a representative of the Child Protection Board is available to clarify the report, to give some updates also sometimes. And the young person and his parents can also comment on the outcomes of the report and give their views on it to the judge. So that's an important aspect of it as well. And then finally, the focus project by Teresom and DCI also looked at Bulgaria, Greece, and Romania, and I looked at their results report as well. And some of the findings there are as well that no special tools for individual assessment exist at least in Bulgaria and Romania. In Greece, it was indicated that there are special juvenile probation officers. They also specifically work for the courts, and they do individual assessments ordered by the public prosecutor. And for Romania, it also was reported that there's an unequal development between rural and urban areas. And as I indicated before, that can be a problem because there might not be specialized personnel to do individual assessments. And also, you will not reach all children. Some are left out who should have or better could have had also an individual assessment. So these are summarized results of that project. So I would like to conclude this part of the presentation in stating that I think that in Europe, at least in juvenile justice proceedings, individual assessment is quite common. It is quite common to look at the needs and the welfare of children and young people, and to have acknowledgement of that also in the sentencing by judges and in applying certain measures. But the way it is done is very diverse, and also maybe it's not always done in a standardized format or standardized way, and that could be something that could be further developed. And many of these individual assessments have, on the one hand, the goal of risk assessments, but also on the other hand, to find the most appropriate disposition. For example, in the type and the length, the duration of a certain disposition. But what I already saw in the poll was very encouraging, that a lot of you also said that the vulnerabilities and the needs of the young person also in the procedure are important in doing these individual assessments. In general, when you look at juvenile justice proceedings, it is quite not so common to make procedural adaptations based on individual assessments. Mostly these adaptations are general for all children and already in place, compared to adults. So for example, that it is not open to the public, a court hearing, or that there is social work involved also in court, but not so specific for specific vulnerable children, for example. Which could be given, I think, more attention, specific children from diverse backgrounds or different ethnic minorities, or children with specific disabilities, specifically learning and cognitive disabilities. I think need more attention, and individual assessment can contribute, I think, to that. So thank you very much for your attention. I see that there are some questions in the chat. I will first close my presentation.
Stephanie, you have absolutely perfect sense of time.
Yes, I see.
It's amazing.
Okay, great.
So we still have 20 minutes for questions and answers. So the first one is about time to undertake the assessment. How long a specialist can make the assessment in your country?
How long, in the sense, how much time they can put in it?
Yes, I guess.
I think for the Netherlands, there are quite strict timelines also, because the Child Protection Board is funded for per report, per case that they do, and based on that funding, you know how much time there is to do the assessment and to write it down in a report, and there are also timelines for reporting, and that the courts should receive it, because when they have a case, they need to have it, I don't know by heart, but maybe 2 weeks before or so. But in general, I think for juvenile justice cases, what normally happens is that there is an interview with the young person and his or her parents. First the young person alone, and then also together with his parents. And these interviews take maybe maximum 2 hours, really maximum. Then the report will be written, and also the probation or the protection worker makes a phone call to the school and maybe to another social worker. So yeah, to estimate, I would say maybe between 1 and 2 days or so. But maybe that sounds already quite long for some of you. I don't know. But I know, because I've been doing that work also quite some time ago, for a little while, and there was also a lot of time pressure put on people who are doing this, because you have this caseload and you have to go through it, and you have to produce, so to say. And when you have a more difficult case, or then it takes more time, of course. Yeah, I don't know if that answers the question.
And the second one is, which service agency is responsible for the individual assessment, and which professionals in particular are involved in it?
Yeah, it is the Child Protection Board. And as I said, the Child Protection Board is working in juvenile justice as well as in child protection cases, court cases where young people are given court orders for care. But these are different assessments that they do, and they do also assessments for juvenile justice cases. And already, for example, when a young person is taken in pretrial detention at the police station, they are involved, and they do a sort of a preliminary assessment. and when a young person is not taken in pretrial detention, it goes like, as I just indicated, that an interview at the office is taking place. And the people who work there are social workers. So they all have a social work background, pedagogical sciences or psychologists, yeah, with no legal professional. And but as I also stated, that police also makes a preliminary assessment, and then there's a lot of case consultation going on between police, prosecutor, child protection board, probation also. If, for example, the young person was involved with probation already, then they also make a report on how that went and what is needed for in the next case. And probation is also mainly done by specialized social workers. Yeah.
Okay.
Oh,
And
the
now,
next question is difficult for me. I
yes.
don't know. Do you know how many individual assessments are undertaken in 2020? I know that also in the Netherlands, there was a large drop in juvenile criminal cases. And I think maybe in 2020 it was raising a little bit again. But I think in the last decade or so, there were less and less cases. But for how many there are conducted, no, I'm not going to guess that. And it also depends very much on the number of cases that you have in total and the number of young people live in the country, things like that. But the rule is that for all young people who go to a prosecutor diversion or to the courts, an individual assessment is undertaken. And there's also a large group of young people who go to this police diversion scheme that I also mentioned. And for them, no individual assessment by the Child Protection Board is done because they have a very lenient sentence. So, and I think this is also practice, that it is done for all these young people. It's a standard form of AI in the EI, I have to say, in the Netherlands. Could you give a brief introduction? I will leave that to June because she will do that in the afternoon. She will explain more about the.
Thank you. Otherwise, it won't have any. I won't have anything to say anymore.
Sorry, I will not say too much then. That will be discussed in the afternoon. And also the final question.
Yeah, because
June
we
could
have
better
in
answer that one.
Lithuania, for example, this tool, Start IV.
Yeah, but June can say more about it. I'm not sure if that's. No, if we do that in the Netherlands. No, I don't think so. Okay.
And one more.
The last question is also very interesting. Is it foreseen in your legislation that at a particular stage prior to the initiation of criminal prosecution, certain educational measures could be taken, and on what grounds? Mostly, this is done based on that the young person has been taken in pretrial detention. But at that stage, there is already, of course, a charge against the young person. He or she is taken in pretrial detention, and then the prosecutor will ask the judge to either, and that's also based on the individual assessment by the Child Protection Board, to either continue the remand to the pretrial detention, or to ask the judge to release the young person on conditions. So then there are already charges and an indictment will take place. But then the conditions are for release are, for example, that the young person is supervised by the probation service, that he goes to school, for example. Sometimes the curfew is also given, Even electronic monitoring can be applied, although that's not used that much in the Netherlands. And also, as part of the probation, it can be said that, for example, a certain training should be started already. Yeah, if that's and that is quite standard practice, because it said, okay, we do not want to have young people for a long time in pretrial detention. And so if he's not a threat to society, or he's not going to obstruct the course of the investigations, then we will release him with these type of conditions. And then at the court hearing, in the end, when in case he or she is found guilty, it is determined what the sentence will be. And mostly that is then also in line with the measures that are already set in place. And that's also all covered in the criminal law in the Netherlands. Yeah. Let me see, were there other questions so far?
I think this is it. And I have one question.
Yeah.
Stephanie, what would you choose if you had to choose just one answer from that pool question?
Yes. It's just one. I don't have them in front of me at the moment.
Maybe Thomas can help us.
Thomas.
Just to show one more time.
Yes, oh, thanks.
Because you said that countries are limited to in scope and in purpose, yeah, and we know that maybe it's lack of resources can influence this limitation, yeah. So probably they choose also from
So yeah, what is then possible and feasible in a country? But when I have to choose one, I think, as you also see from the poll, many of them are interlinked and also overlapping, and also maybe also serving the same purpose. It's really difficult, therefore, maybe to choose one. But if you, for example, the one that has been chosen mostly is also to assess the vulnerabilities of the young person. That can cover a lot, of course, but it's not only about vulnerabilities, but it's also about the current situation of the young person. Although many of them who are in contact with the law are in a vulnerable position. Not all of them. Some are not doing very well, but just make one mistake. But many of them have specific vulnerabilities that need to be addressed. And I think important here is to highlight that it's not only about the outcome in the sense that the best appropriate sentence or measure should be chosen, but also that it should take these vulnerabilities into account during the proceeding. And that if professionals are aware of that, what these vulnerabilities are and what maybe certain difficulties are of the young person, it is better, easier maybe to address that in the proceedings, and to make specific adaptations for young people, and to make it maybe more understandable for them also, and to have them participate more in the proceedings. I think those 2 points are important, although they do not come so specifically out of the law maybe, but I think we can interpret that also from the law. Thank you. It's a very interesting question.
Yeah, it's the main question to discuss. Yeah, because maybe we have questions from our panelists, colleagues. Do you have questions for Stephanie?
Hello. Hello. Yes, I I will put a question to Stephanie if I. Stephanie, in Finland, the minimum age of criminal responsibility is 15. And you said they have special ways of dealing with young children under 15. How do they deal with, say, someone who murders another child? Say a 14-year-old murders a 14-year-old. How do they deal with that? How does individual assessment come into it? And what could be the outcomes of that assessment?
Yeah, I think it's a very interesting question, because there are always, in every country, sometimes children who commit very serious offenses.
Yes.
But as far as I know, in the Nordic countries, the main point of departure is that young people under 15 are not criminally culpable yet. Yeah, responsible. And that other ways are looked into to prevent this from happening again, basically, and to help and these young people. And they have, of course, also institutions and closed institutions. Where young people can be sent to, that they go to an out-of-home placement. But it's not with the goal of punishing them or sentencing them or providing retribution or justice to a victim, but the purpose is to really resolve the problems that the young person has, maybe psychological problems, in development, in aggression, maybe, and to reintegrate the young person again into society with lower chances of doing committing such crime again. So I think it's more about because, for example, in the Netherlands we also have close treatment for young people who commit very serious offenses, and it is very much looking into the personality of the young person, certain personality disorders, giving psychiatric treatments. But it's in the context of the justice system, and you also attach a sentence to it, a punishment, which can be a detention, but next to it you also provide this treatment, basically. But that's because it's part of a justice-oriented system, and in Finland, this idea is that until 15 that does not take place. It's all in the welfare system and social work.
What might be the time limits on that? Supposing you have a 14-year-old who is in an institution like that, measures are taken to support that person, address the behavior, address the problems, whatever they are. How many years do you know how long that can go on for?
I'm not sure, because I think it would be at least until 18 that this child protection system applies. And in some countries that's also even longer. For example, also in Belgium, child protection measures can be until 21 and even 23, I think. So I'm not sure about it but I can imagine that in Finland they also have a little bit longer timelines for young adults. But normally child protection applies to 18, and then you're an adult, so you cannot be, you're not anymore supervised by the government because of problems that you or your family have on that basis, at least. But I don't know for how long.
I ask because when the CRC is aiming for 14 years as the minimum age of criminal responsibility, there have to be answers to the questions: what do you do with children who are under that age, who commit grave crimes? And is there anything known about children who have committed grave crimes in places like Finland, Denmark, Sweden, Denmark, as you say, and indeed in the Netherlands, as to the outcomes when they are in their 20s, when they are adults, as to whether that sort of approach gives better outcomes than the punitive approach, lock them up?
That's a very good question, and I've also been involved in a research specifically on very serious offenses, because there have been incidents in the Netherlands, and that's why also investigations took place as to whether, what are the results, what are the outcomes?
Absolutely, because we're pragmatic people, and we will.
But already in the Netherlands, we have a lot of data, but even that kind of data is very difficult to collect. To know that young person has been in detention and in this treatment, and then what the long-term outcomes
Yes.
are on this kind of treatment. And I think we collect a lot of data and have a lot of systems, but it was very difficult to find that in our systems of the Ministry of Justice and the institutions overlook this. But overall, of course, there's a lot of evidence that only imprisonment is not really effective.
Yes.
And that a treatment is more effective than only locking people up, of course, especially for longer periods of time. So, yeah, better results are expected from that. But yeah, I don't know whether they're doing better in Finland or in the Netherlands in that regard. But
No.
it's also difficult to assess because it's so rare. There are so few people, young people or children who commit these types of offenses. So they are also maybe not really a representative group of most young people who, are in contact with the police in the end. And could be helped without being detained, and also maybe are worse off when they are going to prison.
Yes, it's a challenge to all of us, really. To weave our way through these different concerns and concerns across society as well.
Because the interests of victims and families of victims are also very large in some of these countries.
Well, thank you for that.
Thank you.
I have a question, Stephanie, if I may. If you were a legislator, who would you put in the position of main actor who conducts individual assessment? Is it the child rights institution? Is it probation service? Is it some kind of institution that functions within the court? What is your opinion, theoretically, at least?
I think it's important this organization or institution can work independently. So independent from the courts, at least that it is not having some relation to the courts and to the person who have to make a decision on the case, but that they can really say to young people and parents that they make an independent assessment and outcome of that assessment, and that the court can do with it, because they have their own discretion in making the decision. And for example, in the Netherlands, it's government funded. And I think that's also important, that the government really invests in providing this service. And not that it's a child rights organization that is depending on external funding or which is not very sustainable mostly. And in the Netherlands, it's also difficult what I said with caseloads and that they are paid per case and things like that. But on the other hand, the government provides for this. I think you also mentioned the probation service. And I think that's also a very suitable organization for doing individual assessments, because they have a lot of contact with people already, and sometimes they also already know the young person because they were engaged with him or her before in a case. And they also are social workers. So, but they need to have the time and also the training to perform this extra task maybe, or to have extra staff available who can do individual assessments. Because in the Netherlands, sometimes probation services also ask to do this, but it's sometimes next to the child protection boards to do an extra assessment or give their advice, or sometimes they are the only ones, but they do not the same structured assessment. So it's a little bit vague here, I think, and you better have one organization who can do this all. And very well, probation would be suitable for that, I think.
So what did you choose between two actors? Is it Children's Rights Office or institution, or is it probation?
I think probation, because they have a lot of experience also with working with these young people, and because in their daily work they already have to assess problems on different life domains and how to address this and help young people overcome certain difficulties. So I think they would have quite a clear view on how to make an individual assessment.
Thank you.
So thank you, Stephanie. We are really thankful for you to share that you shared experience, knowledge, and insights, and we are inviting to stay with us today and in June. So now we will have lunch break, and after that we will meet with June.
Thank you very much. It was really a pleasure. And thank you also for all your questions. I hope it was helpful, the answers that I gave. And if there are any other questions coming up, I'm happy to answer them later.